Good morning. I'm Gary DeWaal, and this is Bridging the Week for January 13th to 17th, and today is January 20th, 2020. A non-US based investment and brokerage firm agreed to settle spoofing allegations with the Commodity Futures Trading Commission by payment of a $700,000 US dollar fine. In accepting this settlement, the CFTC emphasized the cooperation of the defendant. Separately, a Dubai court declined to reconsider a fine and ban on assisting financial services firms imposed on a non-US compliance officer by the Dubai Financial Services Authority for allegedly providing false information to it for over 2 years. The compliance officer vehemently disputed the allegations. For us baseball fans, this was an amazing week that resulted in the departure of 3 major league managers as a result of enforcement requirements regarding fair play. So I can discuss the consequences of some regulatory enforcement actions in financial services. Let's get started. The CFTC brought and settled an enforcement action alleging spoofing against Mirae Asset DeWaal Co. Limited. The South Korea-based brokerage and investment banking firm agreed to resolve this matter by paying a $700,000 US dollar fine. The CFTC said that DeWaal's penalty was reduced because of the firm's cooperation. According to the CFTC, the alleged illicit spoofing transactions occurred at DeWaal Securities Co. Limited from December 2014 to April 2016, prior to the firm being purchased by Mirae. The CFTC said that during the relevant time, on multiple occasions, an unnamed trader at DeWaal placed orders for E-mini S&P 500 index futures contracts traded on the Chicago Mercantile Exchange with the intent to cancel them before execution. In one type of transaction, the CFTC noted the trader would place one or more quote-unquote disproportionately large orders on one side of the market with the goal of providing a misleading impression of market depth and attracting market participants to trade on the opposite side of his large orders. Once liquidity entered the marketplace, the trader entered a small order on the other side of the market opposite his large orders, and as soon as it was executed, he canceled his large orders. The CFTC acknowledged that, after learning of the division's investigation, Mirae cooperated with it by hiring an outside counsel to investigate the matter, as well as an expert to review the trader's transactions, and voluntarily produced documents and information. This is another in a series of CFTC enforcement actions where cooperation by the defendant seems to have paid off. Check out the article version of Bridging the Week at www.bridgingtheweek.com for more. A senior compliance officer working in Dubai was fined and prohibited from working in the Dubai International Financial Center for allegedly providing false information to the local regulators for more than 2.5 years. Specifically, in June 2017, the Dubai Financial Services Authority fined Anna Waterhouse $100,000 US dollars and prohibited her from performing any function associated with providing financial services in or from the financial center because she purportedly was quote-unquote reckless in providing information to the regulator on several occasions from January 1st, 2011 through January 21st, 2014 regarding activities of Deutsche Bank's local private wealth management team that later turned out to be false. A financial center specialized independent tribunal, the Financial Markets Tribunal, affirmed the regulator's decision in August 2019. Last month, Ms. Waterhouse failed in an effort to have a financial center court hear an appeal of her decision. Moreover, the financial center court evaluating her application for an appeal required her to pay all costs incurred by the regulator in opposing her appeal efforts. According to the FMT, during the relevant time, Ms. Waterhouse repeatedly told the regulator that Deutsche Bank's local private wealth management team solely referred prospective clients to other Deutsche Bank officers and never provided them with any financial services. However, claimed the regulator, Ms. Waterhouse, quote, was reckless as to the truth of these statements and ignored signs that breaches were occurring, end of quote. The regulator claimed that Ms. Waterhouse became aware by November 2011 that the local private wealth management team was in fact acting contrary to local law and engaging in behavior inconsistent with her representations. She did not correct her prior information to the regulator until late 2013, said the regulator. Ms. Waterhouse vehemently denied these allegations. As I've written a few times recently, compliance officers and CCO annual reports are increasingly in the spotlight. Watch out. And finally, competing motions for summary judgment requesting opposite outcomes were filed last week by the parties in the Securities and Exchange Commission's enforcement action against Telegram Group Inc. and TON Issuer Inc. The SEC claimed that the defendants' offering and sale of quote-unquote gram crypto assets during the first quarter of 2018 constituted a securities offering that was not registered, while defendants claim their first quarter activities constituted the lawful offer and sale of an investment contract that was lawfully exempt from registration and involved the ultimate delivery of crypto assets, grams, that would be virtual currencies and not securities. I have a lot more details and my views on this matter in the article version of Bridging the Week at www.bridgingtheweek.com. Check it out. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. You know where it is. Check it out. I'm Gary DeWaal. Have a nice week, and until the next edition of Bridging the Week, ciao.